Good evening and welcome to this session of live learning classes organized by the Board of Studies of the Institute of Chartered Accountants of India. Nice to be back with you. And so today we'll be continuing our discussions on incorporation of company and matters incidental thereto. Before we begin, let us invoke the assistance of the Supreme Controller of the universe. Sahana bhavatu, sahanau bhunaktu, saviryam karvavahai, tejasvinavadhitamastu, ma vidvishavahai. Om Shanti Shanti Shanti. Good. Welcome and nice to see many of you posting good evening. I see a lot of names there. Thank you for doing this. So I would love to acknowledge everyone, but time really is a constraint. So don't worry. Keep your queries coming. And so whoever is here, I'll greet quickly. Mohammad Akif, welcome, sir. Shanti Gaji, Shreya, Vidya Devender, Jennifer, Pooja Gupta from the Eastern region, welcome, madam. And Mr. Shankaran, Vanakkam, sir. And Ajay Chauhan, wow, Ashutosh, Gunjan, welcome, ma. Rama Devi, Santanamari, I think that's how it is, from southern region. Rito Banerjee, welcome, sir. Hardik, Jai Patel, Kadambari, Lokesh, Kaklota, Rajesh bhai, welcome. Surendran, okay, there are too many people. The number is becoming big. Okay, so Shivam Gautam also welcome, welcome, welcome. All of you welcome. And I have Ruturaj Honmane from the western region giving me a greeting in my language, Tamil, Malay Vanakkam. That's good evening. Thank you, sir. Nice, nice, nice. I'm so happy. Wonderful. Moving on. So we've really covered a lot of ground. We've seen what is memorandum. We saw what is a memorandum and how it should be. We saw all this. We have covered quite a lot of ground. Almost 80 slides we have covered. But still the topic is pretty big. So we also saw this doctrine of constructive notice. Right? Doctrine of constructive notice. Every document, not only the memorandum and articles, every document filed with the Ministry of Corporate Affairs will be considered or deemed to be aware. It will be public document. It will be a public document. Once it becomes public document, every person who is going to have a relationship, every person who wants to have a relationship with company is deemed to have knowledge, presumed to have knowledge. Means even though they have not read the memorandum, even though they have not read the articles, it is presumed, it is assumed that they have read. That is why this is called legal fiction. The minute we have deem, the word DEEM is used in section DEM. It is assumed. Even though it is not so, it is assumed that it is so. Okay, this is something very funny and this is very dangerous also. It is called legal fiction. Not only in Companies Act, you will find it coming in income tax also. Like you have deemed dividend, correct? 222E. A loan given by a company to its person who is substantially interested will be treated as dividend. Though, I mean, the intention was not dividend. It was a loan. But to the extent of accumulated profit, it will be deemed to be dividend. Meaning it is, even though it is not dividend, the law will treat it. The law will consider it as dividend. Deeming, you know that. So I'm just giving an example of deeming. So all documents filed with Ministry of Corporate Affairs are public document. If once they become public document, every person entering into a contract with the company is presumed to have knowledge of the conditions contained therein. This is called the doctrine of constructive notice and is applicable to all documents filed with the ROC. This is under section 399 of the Companies Act, which is not in your syllabus, but this happens. Why I am stressing this doctrine? Because if you have understood the doctrine of constructive notice, it will be easy for you to understand indoor management. Once you understand doctrine of constructive notice, it's like a coin. Once you know the heads, the tail will be easily understood. Head, tail, two sides. So this is one side of the coin. You will see the other side. Meaning, I am third party. I am entering into contract with the company. I am deemed to have knowledge of everything. Even though I have not read the memorandum, it is as if not read. Okay. Sir, any Mohammed Khan, any query relating to uploading or other administrative matter, kindly send a mail to the BOs directly. Please do not ask the faculty because I have no control over uploading. Regarding the notes, if you mean the notes, I have already uploaded preliminary. It is there in the portal. The incorporation will not be done till the topic is completed. Okay, the policy is uploading will happen only by my policy, not BOI's policy. My policy is uploading will happen only after the topic is fully covered. Fully covered. If not fully completed, I will not upload. This is my policy. I have been following it consistently, 7 batches. Now, this is the first batch of the new method. So, technically, 8th batch. So, I have been like this. So, kindly wait. Don't worry, Aram say, why do you see disturbed mind, confused mind? Don't worry. You will get it. Preliminary has already been uploaded. If you think it is not there, kindly talk to the Board of Studies. Please do not disturb the class with queries. For example, Geeta Rani, I didn't get to know about Sunday class. I'm very sorry. Luckily, it's a video. You can download the video and watch it. There are many students who have not attended these classes, regularly, but they have downloaded the videos. They have watched it. Like the methodological guy, Ekalavya, they have not had direct interaction with me like this. They have cleared the exam, Baba. Can you imagine? These people, with sincerity, they have listened to the teacher. With belief, they have listened to the teacher. They have learned the subject from him. And they have cleared the exam. Then they will send, somehow they will get my number from LinkedIn or whatever. And they will send a message saying, sir, I have cleared the exam. I watched your lecture like that. Feel very happy. I will bless them. So see how, without even meeting me, without even seeing like interacting with me like this, with belief in the teacher, they have listened to my lectures. Whatever I have taught was good for them. And they have read the material of the institute. They have cleared the exam. Some of them have got 60 plus and all. So no problem. You have not lost anything, Geeta Rani. The lecture will be in the portal. Download it. Spend about 2.5 hours on another Sunday. Your gap will be filled up. And don't worry, nothing which was taught in that session would be a problem. I will again explain, but it would have been nice, in the interim period, you had downloaded the video and watched it. Chala. Now, we have already seen this. Memorandum, clauses, various clauses we saw one by one. Then we went to name. Now we are going to see name clause, then situation clause, like that. Okay. Now, so from now on, some humble request. One, please do not put process-related queries in the query board. Process-related means I don't have the notes. When will you upload the notes? How I should take notes, like that. Also, don't put, you know very well that useless argument about Hindi. Please don't make that point. I cannot teach in Hindi. That's the end of it. We already spoken many times about it. I think this is where it stands now. And also, Board of Studies very clear. I should teach only in English. So there is no need for you to waste your time. I think. Also, this chapter is chapter number 2. Chapter number 2. Incorporation of company and matters incidental thereto. Even if you have not attended previous lecture, please attend this lecture. Whatever you learn here, good. Then go back, download that video, watch that also. Nothing will happen. Okay. So, no problem. See, memorandum has 6 clauses normally. 1-person company will have 7th and 8th clause. The name of that 1 person and the nominee ka naam. Now we are going to see each clause again. We are actually doing a revision. Name clause. Here they are putting some more conditions on name. They say the name stated in the memorandum shall not be identical with, means same, exact, or resemble. That day I gave you, in the last class, I gave you example of what is identical and resemble. Identical means like twins, identical twins. Can't distinguish, same name, you can't. Impossible. Because before we incorporate a company, we will do a research in the MCA website, name search we will do. We will check whether similar or identical name is there. Then we will analyze it and we will give. So identical with or resemble too nearly to the name of, resemble too nearly. For example, I told you, Reliance Industries Limited is already there. Now you cannot ask for a new name, which is Reliance Enterprises Limited, because Reliance is too well-known a brand. Industries is also there. Now, merely by putting enterprises, you cannot escape. Because Reliance Enterprises, the Reliance is there, common. Sorry. Unless you have to totally distinguish, even then it will be very difficult. You should go to some field where Reliance does not have a company, and there you have to do it. Even then you may be in trouble. I will tell you why. When we come to rectification of name, you might be in trouble. So, yeah, I agree with Dinesh Kothari. No more queries in between session. Every time I make up my mind, Dinesh ji, but then I see best thing is for me to keep the query away. If I see it, I will answer. So let me teach. So if you have a doubt about the topic, please put it in the query pad. The time now is going to be 6:15. Exactly at 6:45, I will take up queries. Or when a topic gets over, I'll take queries. Otherwise, I will not see queries. So please don't use it to talk to me. I will not be seeing it regularly, as rightly suggested by Dinesh ji, Dinesh Kothari ji. I will not be seeing it continuously. So do not waste your time. Later on, I will answer it. Okay. So any argumentative type of question will have to wait. I will react to it, but not immediately. Where you are saying, maybe this is right, that is wrong. That has to wait till I see it. So identical with or resemble. So this resemblance is a really, really painful thing. What is resembling? For example, even homophones, meaning two words that are not spelt in the same way, but heard in the same way. When they are spoken, they are heard, okay, in the same way. For example, K-N-I-G-H-T, knight. Okay, K-N-I-G-H-T is a soldier. In those days, English in the Crusades, in the British periods, in the old period, the knight, K-N-I-G-H-T, was a warrior. K-N-I-G-H-T. You know very well, N-I-G-H-T is also there. Night. Night means Rath. Okay, that is night. When the sun is setting and we have the moon coming out, that is called night. See, these two words are homophone. That is, when I use the word night, you might get confused whether this word or that word. So those are also treated as resemblance. Now, so also, the name stated in the memorandum shall not be such that its use by the company will constitute an offense under any law. See, they might have passed a law. As of now, there are no laws prohibiting names, but they may pass. If so, it should not. Is undesirable in the opinion of the central government. Now, friends, I am not covering this in this slide. It is there in the Institute Board of Studies material. You please read it there. That is, there are certain words which are used like central, national, Bharat. These are words which are reserved words. They cannot be used by everybody. So, if you want to use those words, these words are specified in Rule 8B. These words are specified in Rule 8B. If you want to use those words, you have to get the previous approval of the central government. How? Well, you have to apply to that ministry and you have to get ministry and you have to get that letter. With that letter only, you have to approach the MCA. Otherwise, they will simply reject it. Undesirable. Like that. Now, undesirable meaning it will give the impression that the company is connected with in some way, in any way, connected with or having the patronage or support. Patronage means support or blessing of the central government, any state government or a local authority, some kind of a governmental support. So no company should misuse this. See, suppose you see the name National Institute of Talent Improvement, NITI, not NITI, that is Niti Ayog. This is National Institute of Talent Improvement Limited. So immediately you think it's some government organization. So they may be conducting classes and giving certificate. So many students may join thinking that they are getting some government diploma or certificate just by putting national. So they said, no more this. Okay. In those days, there were some companies that were formed with the NIIT and all that. But now you cannot. Because at that time, this rule was not there. You'll have National Institute of Information Technology and NIIT. But still, I think at that time, they did have some support from government at that time. I don't know. Whatever it is, you have to obtain the permission of the previous approval of the central government. Okay. As I told you, there is three rules are there. Rule 8, 8A and 8B. 8 is given elaborately in the Board of Studies material. Please go through it. For want of time, I am not doing it. 1. 2, it is pretty simple. 8 provides concrete examples. When a name would be considered, when one name will be seen or one name is considered as resembling another. So they give 2 names. They'll say, hey, this is resembling that. Also, this rule 8 clearly says, only in these cases it is resembling. Other cases, it is not to be called resembling. Like that. So you have to go through 8. Before we get once we get a name, we go through 8. That is one of the activities we do when we get a name. See, when a person comes for incorporating company now, first thing I ask is what name? Okay. Because everything will hinge on that. If they give me a name, I'll go search for it. If already existing company is there with similar name or identical name, I'll tell them, please kindly change your name or allow me to give some changes, some minor modification. Exactly as you have, I may not be able to incorporate. They will say, no, I want. Hey, come on here, if I apply, it will be rejected. So we'll go. Then we'll be given time. We'll see that. I'll be given time. 15 days time I'm given to modify. So if there is any comment, they'll put a comment. And within 15 days, I have to change it. But that again, they won't allow every time. 20 days limit is there. Within that 20 days, after that, you have to again apply. One more renewal possible. Then one more 20 days, another renewal. It is there in your material. You can go through that. 2 renewals are possible. 20, then another 20, then another 20. That's all. So, you can renew it. But only for that period, then again you have to pay fees. If you want total 40 days, then 3,000 rupees you have to pay straight away. Okay. Generally, we reserve it 2 times. We reserve the name 2 times. If the promoter is not coming to that thing, we will simply close the file, say bye and go. Because beyond that, he is not interested. Rule 8 provides concrete examples. Rule 8A and 8B give instances of undesirable name. I told you, then they will say you have to get the previous approval of the central government. This is not given in your Board of Studies. Your material is only telling you to refer to them. From an exam point of view, not important. Okay. Rule 8 is given in the BOS material. 8B is given in the BOS material. The names. But don't mug up that list of names, ma. There is a list of names there, Bharat, Central, National and all. Please don't mug up all that. Waste of time. Don't do that. Okay. Use your intelligence. If it's seeming to be like a public name, it will definitely undesirable. Okay. Use your common sense or go through that list and make a broad idea. So you will see what are those names. Most of them are names that give impression as if it is government. Okay. So you have to be careful. Now, MCA has also directed that the registrar of companies concerned should exercise due care to ensure that the names are not in contravention of the provisions of the emblems and names Prevention of Improper Use Act. So you should also be careful about that. See, the national flag cannot be used in any logo, etc. Generally, nothing to do with name. National flag, no. You cannot use the national flag. That is why they won't use the national flag, but they will use the colors of the national flag. They will use the three colors and blue, mix match, to create an impression of patriotism. Now, we come to the next point about name, which is reservation of name. So, a person may make an application in SPICE plus form INC 32 Part A. I told you, there are two parts, Part A, Part B. Part A is for name. Part B is for incorporation. So, the name application will be in Part A. There you will give the name of the applicant, etc., etc. Then they'll give you three options. You can give three choices. One of them they will give. But provided it is not identical or resembling, also not undesirable, they have many conditions. You have to go through 8, then you will see. One thing is, the name of the company should contain a proper noun and an activity description. So if you want industry and all, then your authorized capital has to be high. Because industries, so huge, 5 crore. You can't just like that have industries. Because if that person is going to run a small petty shop, why he'll call himself industries? So this gives a wrong impression to the public. So all this control, all this regulation on name, why? Because public may misunderstand. The public may be cheated by such names. So they want to be clear that the name of the company should be such that nobody will get cheated. Similarly, suppose I am starting Reliance Enterprises Limited. Somebody may think it is connected with the Ambani Group. Some fool may think. I'm not saying everybody will think. Or I may go to some rural part and there create the impression that I am part of Reliance Group and do some fraud. So in order to prevent that, they say your name should not be identical with another existing company, resemble it, or any other undesirable words should not be there. So subject to that, you will be given a name. For example, currently we are in the process of incorporating 2 companies. Currently work is going on. My people are on the job. So one name we have got today. Today only that my staff has called and said, sir, I'm sitting in Coimbatore here. So he called me and said, sir, name has been allotted, approved. Wow. But that will be available only for 20 days. In case they are not giving this name, they will give you permission to resubmit within 15 days. Okay, they will say, kindly change it and give it. One opportunity will be. You can do that. Whatever it is, finally they will approve it. Upon receipt of an application for the reservation of the name, the registrar may, on the basis of information and documents furnished along with the application, reserve the name for a period of 20 days from the date of approval. Friends, can you imagine? Once upon a time, we got it for 30 days. That too, the fee was only 500 rupees. Now, for 20 days, the fee is 1,000 rupees. Another 20 days, 2,000 rupees. If you want 40 days, then 3,000 rupees totally. Well, that is 1,000, then another 1,000. Then last 20 days now, which is the limit. Third time beyond that, they won't renew. That is 2,000. If you want for 40 days, you can pay 3,000 and take it in one shot. So MCA has become a sort of a collection agent for money. They are very interested in collecting money. Huge. So 1,000 rupees, first time, you get your name. 20 days reserved from the date of allotment, 20 days. Okay. So today I'm getting approval means don't count today. Whenever the word from is used, from, here you can see na from. The minute the word from is used, then you should not count the day on which that has happened. So the day on which the name is allotted, no, ignore it. Then count 20 days. At the midnight of the 20th day, your time is expired. You have to again apply. If you want to renew it before the expiry, before end of 20 days, you have to renew it. Another 20 days, pay fees. Another 20 days, totally 60 days. Okay, this is the limit. Of course, these are all procedural rules in that. My humble view is that chartered accountants, we should not be too much worried about these procedural aspects. Because invariably, some of this work we will depute it to a company secretary who is possibly aware of it. Anyway, it's good to know. And I think the institute wants you to know from the exam point of view, you must be thorough with these 15 days, 20 days and all that. So please, they are expecting you to be aware of the forms and all that. Possibly because I have a feeling that I may be wrong. I'm having a feeling that once you complete your intermediate exam, one group or two groups, whatever may be the prescribed mode, you don't please educate me. You educate yourself and do it accordingly, because I am Buddha and I have completed my CA. I don't have to know about the procedure. Please don't educate me. If you think it is one group, two group, whatever it is, after completing that, you have to join what is known as articleship with a CA firm. At that time, they want you to be knowledgeable about the procedures. Because as an article clerk or an intern, if you don't like the word article clerk, I will use the word intern, INTERN, trainee. As an intern, trainee, you will have to do this work for your boss or for your firm. Therefore, they expect you to be knowledgeable in the procedure and forms also. This is my view. So in the new Board of Studies material, I find a lot of importance is given to form numbers and the procedures. So I feel they will ask you a question in the exam on that, which could be in the nature of multiple choice questions, MCQ questions. So for this activity, which is the form number, you should know. So this is something you can do. My view, and just as a teacher, I'm telling you, don't accept it, don't accept it. Please, if you don't agree to me, don't put it in the query pad. Keep it in your mind. If you think I'm saying something correctly, take it and work with it and do something about it. Okay? If you think what I'm telling is useful, use it. Otherwise, chod. Go on with your life. Don't worry about that. Don't educate this old man. Okay. So, cancellation of name. Now, the name has been reserved. Later on, the ROC wakes up and finds, it is found that the registrar or the MCA wakes up and finds that name was applied by furnishing wrong or incorrect information. Then, if the company has not been incorporated, meaning still the name is allotted, but not the company not incorporated, then the reserved name shall be cancelled. And the person who made the application shall be liable to a penalty, which may extend to 1 lakh rupees. For example, they might have forged something. For example, I'll tell you a simple example. Easy example. There is one company, let us say, Superb Industries Limited, SUPERB, Superb Industries Limited. That is a parent company. Now, let us say 3 brothers, father mar gaya, papa mar gaya. Then what happened? These 3 fellows are fighting. The younger brother wants to incorporate one company, Superb Constructions Limited. Now, if he wants to incorporate Superb Constructions Limited, he has to get no objection certificate from the Superb Industries, in which he is also a director. You understand? In which he is also a director. But without the knowledge of the other directors, by forging the letterhead and all, he is producing a document called NOC. Based on that, he is getting the name Superb Constructions Private Limited. MCA will never know this. But the other 2 brothers, suddenly they discover some clerk or somebody will go, sir, Saab is incorporating company, Superb Construction. Oh, really? Then immediately they will call the chartered accountant, their auditor, the family auditor. The family auditor will quietly hedge because for him, everybody is important. Then he will suggest a lawyer. Then they'll go to the lawyer or preferably company secretary. Then that company secretary will send a letter to the MCA complaining, saying, Superb Industries Limited has not given the NOC. this has been forged. Immediately, luckily the company has not been incorporated. Then the reserved name shall be cancelled. And the person who has made the application, meaning this third brother, will be liable to penalty, which may extend to 1 lakh rupees. Of course, if any CA or company secretary has advised him or assisted him, that lady or gentleman will go for professional misconduct. Complaint will be there. So better not get into this type of activities but I'm telling you example how it can happen. Name has been applied by furnishing wrong or incorrect information. If the company has been incorporated, then the registrar may, after giving the company an opportunity of being heard, note it, not the applicant. Are you able to see that? Not the applicant. Once the company is incorporated, an artificial person, separate legal entity comes into existence. So that entity is given an opportunity of being heard. Also, the ROC will politely tell the company, change the name within 3 months. Pass a special resolution. Sorry, pass an ordinary resolution. Change karo. Or if that company is not responding properly, then the ROC, Registrar of Companies, he is the guy who registers the name of the company. Okay, every state has one ROC. 2 states have 2 ROCs. We already saw that. So those of you who joined late don't know what is ROC, Registrar of Companies. Okay. Every region has regional director. So regional director is the boss of the ROC. Regional director is superior to the ROC. This, you might think why this fellow is telling this unnecessarily. When I come to situation clause, you will know the need, why I am telling this. Okay. So whenever we say registrar, ROC, Registrar of Companies, all are one and the same. Same admi, not different, not alag. Same. Okay. So the registrar, instead of directing the company, see, we always say the peacock, if it wants to, you have to take that peacock feather, beautiful feather, peacock. So you go to the peacock and tell, please give. The peacock is not giving. What do? You catch the peacock by the neck and tear the feather out. That is the treatment. In case they are, once I told you respectfully, I told you, change it. Okay. You are not changing. Then what to do? Take action for striking off the name of the company. Or in case the company has already, acquired some property or loan, whatever, then you cannot strike off. So long as any financial transactions are there, company cannot be struck off. Means striking off the name is simple. How did, at the time when the company was incorporated, what happened? Name of the company was entered in the register. That's all. Incorporation, nothing. It's a legal act. The registrar in the register of companies maintained by him, he added the name of this company. That's all. Now, he say, hey, this company is Ganda company, ma. It's not, it has been incorporated by giving false information. You remember, same thing we saw when a company is incorporated by giving false information. Do you remember that? Same thing. Here, the name has been allotted on the basis of wrong or incorrect information. So he will say, I only entered the name now. He will give one opportunity to the company one more time. First, he will say, please change, not change. Then he will send a letter saying, hi, if you don't change and you are not changed it, I will strike off your name. Then he will go for the procedure for striking, which is there in the final syllabus, not here. Don't worry. That striking off of the name is the final syllabus. Striking off simply means removing the name from the register of companies. How it will be done is elaborate procedure, which is there in the final syllabus, not in your intermediate syllabus. Chalo. Suppose the company has acquired assets, borrowed money, purchased goods, something, then you cannot strike off. For striking off, the balance sheet of the company should be only on the assets. Assets should be only cash and only shareholder. Finally, that money also should be paid to the shareholder. Katham, nothing. Then strike off. Even if one liability is there, even if one asset is there, you cannot strike off. Okay. So you have to make a petition for winding up of the company. Okay. Means there will be a liquidator, asset will be sold, liability will be paid, surplus will be returned to the shareholders, and if any, or else they have to contribute, if any, close. Go to the tribunal. That's a procedure. How to wind up a company? Final syllabus. It's there in yours. When you clear intermediate and final come for final, after you finish your final examination, you will study this in self-paced module. At that time, you will study this. Now we move on to articles of association. These are nothing but bylaws. Okay. They are the rules and regulations that govern the conduct of the affairs of the company. Article definition is given, usual definition under the Companies Act, which has nothing will be learned from a definition. Whenever the Companies Act you find a definition, it will not define. It will merely give more confusion. Article means articles of association of a company as originally framed. Originally framed means not framing of picture. Framing means laying down, writing. That's also called framing. Sometimes we say Dr. B.R. Ambedkar was the framer of our constitution. Framer means what? He is the man who wrote it. He is the man who designed it. So like that, as originally framed, as originally written, or as altered from time to time, or applied in pursuance of any previous company law or of this act. Whatever it is, the minute the word articles is used, it means articles of association. Articles are the bylaws. Okay. They are the internal rules and regulations that govern the conduct of affairs of the company. Internal rules. Remember, the articles of association, when filed with the ministry, registrar of companies, also public document. So I am a third party. I am supposed to have read the articles also. Suppose in that articles, this will become very important for you when you come to indoor management doctrine. I am a third party. I am deemed to have read the articles, memorandum. Okay. I know what the rules and regulations are. Even if I have not read, I am deemed to know. Okay. For example, if the articles are saying company can borrow money up to 1 crore, director can borrow. Above 1 crore, resolution should be passed by members. Up to 1 crore, directors can borrow, no need for shareholder approval. Beyond 1 crore, they have to get approval of the members by passing resolution. I know that. I have read the articles. I know that. So I should ask the directors, I am now lending you 5 crore. Have you got that resolution passed? Yes or no? We have passed. So they produce one certified copy of a meeting held resolution. I verify with the ministry. MCA website, I have to verify whether it is there. Yes, it is there. Then that too, it will be there only if it is a special resolution. Ordinary resolution, it won't get uploaded also. So I have to get a certified true copy from the director who will sign certified. So that's it. Beyond this, I cannot go. Are you able to understand? I cannot actually go and find out whether that meeting was actually held, whether the voting was done and all. I cannot know. It is not possible. But I should know what the rule is, because that is there in the articles. So they are public document. So the articles of the company shall contain the regulations for management of the company. The articles shall also contain such matters as are prescribed under the rules. Some things are under the rules, and even section, they will say articles should provide for this, provide for that. Unless the articles provide otherwise, like that they say. Or there, for example, for issue of bonus shares, there should be provision in the articles. Like that. Okay. A company may also include such additional matters in its articles. Okay, like that. Now, the formats of the article. See, you don't have to take the trouble of drafting the articles. Ready-made articles, formats are available based on your type. If the company is limited by shares, F. Limited by guarantee and having share capital, G. Please note it, my dear friends. There, you remember table A, B, C, D, E, na? 5 tables. There, B was limited by guarantee and not having share capital. Let's check up. Why have doubt? Huh? After all, it is the same power. See, do you notice table B is Memorandum of Association of a company limited by guarantee, not having share capital. Okay. Here, G, there is a second from the top, is limited by guarantee and having a share capital. See, when you study like this, you will remember better. Compare and study. So now you know. A, having limited by shares. B having guarantee, limited by guarantee and not having share capital. That idiot Srikanth told me, I should remember. The minute you say limited by guarantee and not having share capital, what is the next one? H. There C will be memorandum of a company limited by guarantee and having share. Here, limited by guarantee and not having share capital. Table H. Also, unlimited, having. Not unlimited, not having. So like that, you can easily remember. My dear friends, some of you are asking how to remember. I'm saying only way to remember is reading again and again with understanding and interest, not mechanically. Once you, with interest, with happiness, with joy, with involvement, you read, you'll remember. With hatred, with lack of interest, when we read, we don't remember, we get bored. Any subject, not only company law or corporate and other laws, every subject, whichever subject. See, for me, maths was a weak subject. I hated it. But even that subject, with involvement, when I studied, I got 50 marks. Statistics, I got 60. So like that in those days. So there are subjects where we are not comfortable. There also you can get marks with involvement if you read. See, like this. Table F, G, H, I, J. Okay, this. So it goes into the mind and sense. Okay, there is no other way, my dear friends. If I know, if I do any research and I come across any other way by which just by closing your mouth, eyes like this, I will make a hole in your head, put a pipe, and the entire subject I will push it into your head. If such mechanical, advancement in technology happens, definitely I'll keep you informed about it. But until such time, my dear friends, the only way to remember is by studying little deeply, with little more interest. That's it. And comparing and contrasting. Then easy to remember. Okay. Again, my humble suggestion to you. Some people have good memory. So for them, slightly better. Some people do not have good memory. They have to struggle a little more. Okay, I would understand. Some people have natural aptitude in mathematics. Some people like me do not have natural aptitude in mathematics. So I have to struggle more. I have to study more. I have to listen more carefully to my teacher. I should not counter my teacher. The gentleman who taught me mathematics is a gentleman called L.S. Shivakumar. For lifelong, I am grateful to him because I have to become CA. Mathematics is the only hurdle. All other subjects I am thorough. Yeah. Mathematics is my only hurdle. Can you imagine? And that subject, this gentleman taught me. In fact, he used to smile at me and say, Srikanth, you won't understand. You do what I say. Like that he will say. D'Alembert theorem, he will say, Srikanth, you won't understand. Step 1, step 2, step 3, mug up, mug karo, go and write. I did it. What to do? I trusted my teacher. If my teacher, I tell him, sir, teach like this, sir, teach like that, sir, teach in Hindi, sir, teach in Gujarati, like that. If I tell, then what is the use? Whatever the teacher teaches, we will learn. However the teacher teaches, if I am interested in the subject, I will learn. Okay. Now, model articles. The company may adopt all or any of the regulations contained in the model articles applicable to such company. This applies to a company registered after the commencement of this act. So, you can say, I do not want to have my own articles. I will straight away adopt table F. Table means limited by shares. Whatever, whichever you are, that table. So, but this can be done only by companies which are incorporated after this act. Because before this act, these tables were not there. There were different tables. Articles was table A. Memorandum was table B. Okay. So in the old law. So those companies will continue. But in case there is a conflict between that articles and the model articles, then the model articles will prevail. If the articles are silent, the appropriate provisions of the model articles will prevail. If the registered articles of such company does not exclude or modify the regulations contained in the model articles, then those regulations shall, so far as applicable, be the regulations. So where those articles are saying something, that will prevail. Where they are silent, then automatically the provisions of table will apply. So, but now if you are incorporating a company today, you will go to Spice Plus Part B. Therein you will select which table. The minute you select the table F, automatically that full table will come there. Then you can make changes. You can modify the regulations to suit you. You can remove one clause and put your clause. But be careful. The articles of association cannot exceed the provisions of the memorandum and the Companies Act. So, if there is any conflict, if there is any difference between the articles of the company and the Act, Companies Act will prevail. Companies Act is superior. Companies Act bada hai. Okay, that is more. Why? Because articles will be less than Companies Act. So, in terms of order, Act is supreme. Memorandum is supreme to article, but it is less than Act. Memorandum cannot provide for anything which is not in the Act. Act is supreme. Articles will be subject to Memorandum and Act. So this is the pecking order. Act means it means section, rules, everything. The Companies Act 2013 together with the rules, everything, Act. Then Memorandum. Memorandum less than Act. Articles less than Memorandum and Act. Okay. If the articles of the company are silent on any subject, then the model articles will prevail. Friends, please note, the model articles in table F, table G, etc. are in Schedule 1. Schedule 1 is part and parcel of the Companies Act 2013. Are you able to understand? The Companies Act is complete with the schedule. 7 schedules are there. Till the end of the 7th schedule, Companies Act. Okay. So, your memorandum and articles cannot be superior or different from what is provided in the Act. So, if the articles are silent, the appropriate provisions of model will prevail. Also, you cannot contradict the model articles. Okay. But in some cases, the law itself permits you. We will see that. In some cases, they say, your articles can be different. No problem. Go ahead. In those cases, you can. Other than that, no. So, just to summarize the concepts, memorandum is the constitution and charter of the company. It lays down the parameters that define the company's relationship with outsiders. One of the important clauses in the memorandum is the objects clause. The object clause defines what the company can do, what it cannot do. The articles are nothing but internal regulations. They define the relationship. It defines the relationship between the company and the members. And the members inter se. Inter se is a Latin term. Inter se, I-E-N-T-E-R space S-E, means among themselves. Inter se, among themselves. That's what it means. Okay. Now, why can't I say among themselves? Why I am using Latin term? I am not using Latin term. This is there in the Board of Studies material. Law paper, you will find lot of Latin terms are there. Why? Why? Why in law subject, even in your Contract Act, you might have studied many Latin terms. Caveat emptor, nemo dat quod non habet, qui facit per alium facit per se. Am I correct? consensus ad idem. I mean, there are about easily 100 Latin terms. So it's nice to quote if you quote. Suppose you write among themselves, you will not lose marks. But if you write inter se, slightly you will be seen as superior. Are you able to understand? These are small ways to get more marks, that's all. If somebody is saying, I won't write Latin terms, I will write equivalent English terms, nothing will happen. So long as your answer is correct, you will get 60% of the marks. The journey from 60 to 80 means the marks provided is 5. Reasonably correct answer will get 3. With a somewhat bad handwriting, but correct answer, examiner will get 3. Beyond that, if you want to go, 3 to 4.5 journey. Every question 3 to 4.5 journey, 3 marks to 4.5 marks. That journey, good handwriting, reasonably good knowledge of English, quoting Latin terms, quoting sections, quoting case law, 1 mark, half a mark more, like that. You will move towards that. If your handwriting is very good, straight away 4. Even though you are not quoting sections and all, no problem. Straight away 4, like that. I know this is very unfair, this is unreasonable, but that is how it is, whether you like it or not. I know it is unfair. Don't even waste your time putting in the query pad, it is not fair, unfair. I agree with you. Don't waste your time putting in the query pad, it is unfair, not correct. I agree with you. Okay, that is why. That is why they were trying multiple choice as an option, MCQ. Problem with MCQ is, professionals, it is MCQ, we cannot be tested fully. One method of testing is MCQ. Also, we have to give elaborate answers also. Then only the institute can know whether you actually know the subject or whether you have just mugged up the answers and come without understanding. So, how to know whether you have understood the subject? Only way is to write descriptive answers. So now it's clearly understood that professional examinations cannot be 100% MCA like IAS and IPS and all. It cannot be done that way. So now they are hybrid. So as you said, 40% MCQ, 60% descriptive, some method. Okay, experimenting. In those days, there was no MCQ at all, only descriptive. So MCQ handwriting doesn't matter. You can escape. People who don't know English that well, people whose handwriting is bad, they'll get an advantage. Okay. But even there, if you know the subject well, you will always get a mark. Okay. Is that? Anyway, this is my, again, sometimes, I might waste your time giving such inputs from the exam point of view. Please don't mistake me or get angry with me. Just take it or leave it. If you don't like it, leave it. Don't waste your time putting comment in query pad. It lays down, so coming to the scope, the memorandum lays down the scope beyond which the activities of the company cannot go. This is very, very important. That is why memorandum is the prime document. An act done by the company beyond the scope of the memorandum is ultra vires. In fact, this is a doctrine by itself. Ultra vires. Ultra means beyond. Vires means power. So ultra vires means beyond the power. Beyond the power. Okay. It cannot be ratified. Sorry, I don't know how I got that English. One sec, I will just correct that. Now, that's why I don't upload my notes fully. Ratified. Okay. Now, yeah. So it lays down the scope beyond which the article cannot go. It cannot be ratified. Already we saw the word ratified. I'm once again explaining. Ratified means when an act is done, which is not in accordance with the rule. Later on, you can ratify. You can give permission afterwards. I sent my servant or I sent my employee to buy a shirt for me. I sent him to buy a shirt. I told him, I gave him 2,000 rupees and I said, I want light blue color shirt. I want light blue color shirt. So what is the instruction? Clearly, to my man, my driver, please buy light blue color shirt. He went. He is a good boy. He wants to do good for me. He goes there. He doesn't find the light blue. Or maybe he's colorblind, whatever. He sees another color, which is like, we call it, the color of Lord Rama. It's neither blue nor green, sort of greenish blue. He buys that and not the color I wanted. I wanted pure light blue. As you can see in the screen now, this is light blue. Whereas that gentleman bought greenish blue. Now, has he obeyed my instruction? No. But I see the shirt. It's nice. I like it. Then I ratify. I tell him, chalo yaar, you did it. I'm happy. No problem. Go. He has not done what was told, but after the event, I am ratifying his act. I am saying I will accept it. Are you able to understand? Ratify means to accept a transaction which is incorrectly done, to accept a transaction which is incorrectly done after the event. Usually this will happen with employees and agents. I have an agent, I tell him to do something, he goes beyond his duty. But in my own interest, maybe it is beneficial to me, let us put it. So I will say, chalo, maaf, you leave it. I will accept your request for maaf. I'm allowing you. That is called ratification. But if your board of directors are exceeding the conditions of the memorandum, even the members cannot ratify. See, please understand the relationship between the company and the director is principal and agent. Are you able to understand? Company here meaning members, and the director is principal and agent. Now, principal has the right to ratify act done by agent beyond his power. But if it is something even the principal cannot do, how he can ratify? Now, for you and I, there is no limit here, except for law. Everything else we can do. But company, no. Company is further restricted by the memorandum. So anything done which is beyond the scope of the memorandum by the directors on behalf of the company is void, ultra vires. It cannot be ratified even by all the members. Please understand that. All. Why all? Even majority, I say unanimously we'll clear. Even then, it cannot. Sir, I can ratify something only if I can do it. Suppose I had gone to that shop, I saw that shirt, at that time I could have taken a decision. Let me buy this greenish blue shirt. It looks good. I could have done it. On my behalf, this fellow did it. Though I didn't tell him to do it, he did it. So I will ratify. But if it is something I cannot do, suppose it's a criminal act, then somebody does it on my behalf. Okay. Suppose I'm sitting at home. I'm feeling very unhappy with one person and I'm saying, I wish that fellow can be murdered like that or killed like that. So my driver is listening. Oh, my boss wants that fellow to be killed. So this fellow goes and cuts his head and comes and says, boss, I have done what you want. Can I ratify? Because it is something even I cannot do. Here it is a criminal offense. Only thing I can try to escape is I can say, Baba, he did it on his own. I didn't tell him to do like that. But it cannot be ratified. You understand? Something. I'm giving an example of an illegal act. Illegal act 100% cannot be ratified. Illegal. Illegal means that which is not in accordance or that which is not according to the law. Contradicting the law. Disobeying the law. Okay. This is memorandum. So memorandum is a superior document. Whereas articles is just a rules here. So anything which is done beyond the scope of the articles, okay, can be ratified by the members. Okay, sorry, again, there's a correction. Any acts done beyond the scope of the AOA. Some of you may be having doubt on what is this MOA, AOA. I'm sure you are not having a doubt. It's still Memorandum of Association. MOA, Articles of Association, AOA. Okay. Short form, abbreviation for easy telling. Memorandum is subject to the Companies Act 2013. Okay, it cannot contain anything contrary to the Act, but it is superior to AOA. Already I told you that. But the articles are subject to MOA as well as the Act. So this is supremacy, which is supreme. Act is supreme, then memorandum. Then articles. Okay. before we go to entrenchment, which is slightly interesting, but you might have some doubts. I will take up any queries that you might have quickly. So I'll quickly take in queries. Yeah, Ravneet Kaur is asking, there are 11 points given in study material regarding differences in name which resembles. Don't mug up, but know it. Go through it once. Take a paper and write short form. That is how you take notes. Somebody was asking how to take notes. Take that 1.5 pages and in your notepad, make it like grammatically same spelling or plural singular like that. You take one and you put it. Make it. But good to know. Good to know. Do we need to learn that? You have to learn it. It is there in the material. It has to be learned. I am not covering it for sake of time. And it is simple to understand. Therefore, I am not taking. Indian monuments, yes, Taj Mahal, you can use. That is not undesirable name. You can use. You can use. Taj Mahal, you can use. Taj, like that you can use. Why not? You can use. That is not an undesirable name. Unless there should not be another company. For example, there is a group of hotels called Taj. So there is a Taj group of hotels. You cannot use Taj for hotels. For some other industry, you can use like that. Yeah. Panini-ji, you can review. If you have a doubt, contact the institute for the correct. 15 days given in module is for correction. The 15 days given in the BYS is this one. This 15 days. Okay. If anything, if there is anything which I'm saying that you think it's in the material is correct because I've reviewed the material. Don't worry. If you read the material, nothing will go wrong. Okay. Thank you for the good words. Can you join my firm as articleship? You are in the central region. You cannot, because I am in Chennai. You cannot. Because you locate a good firm in Indore or somewhere where or even Bombay better. Go to Bombay. Bombay is the best place to go. Go there and stay. Many of my students from Maharashtra, Madhya Pradesh, I suggest that they go to Mumbai because better go struggle for 3 years in Mumbai, become big. Okay, or start in Indore, then go to Mumbai. Start in Raipur, go to Mumbai. Whatever. Because I'm a Chennai-based chartered accountant. There are two very, very small chartered accountant, medium-sized firm. Whereas you go to big firm, you go to Ernst & Young, KPMG, Price Waterhouse, like that. I will show you. Definitely. I will show you the practical. Not now. When we come to alteration, I will show you. Don't worry. I will show you. I will not forget. Thank you for confirming that necessary information. Okay. Yeah, Rahul Sharma says, I'm so happy. Whenever I listen to you patiently, most of my notes, little patient. Anyway, no queries. Thank you. How much you average earn in annual, Gunjanji? I don't know how much I earn. Seriously, I don't know. Bhagavan keeps giving and I keep using. That's all. I don't know. That is the reality. One sec. Thank you, Karthik. Moving on with entrenchment. Now, entrenchment is a new concept. It was not there in the Companies Act in those days. In those days, there was no entrenchment. So, this is a new concept introduced by the Companies Act 2013. You will see in your Board of Studies material, you will see, they will give you elaborate description on entrenchment. What is entrenchment? Let us take only in this word entrenchment, let us take only this middle part. Let us take this part. Trench. What is a trench? Trench is a deep hole. Deep hole made in the ground. Trench is a deep hole made in the ground. Why the deep hole means you can, when you're laying the foundation, you can push the foundation, concrete block strongly into the ground. Meaning, entrench means to hold strongly. That is one meaning. Another meaning, entrench means to make it difficult. See, if you go by the dictionary meaning of entrench, it means to hold strongly. Whereas the meaning which we are using here for entrenchment is to make something more difficult. Make something more difficult. Entrenched. For example, something is so much of a habit that we are unable to change it. Okay? That is entrenched. It has become deeply rooted. Entrenched means deeply rooted. Okay? So the moola is going very deep. Okay? That means very difficult to take it out. That is the meaning. Difficult. So entrenchment is the process by which amendment or alteration of a clause in the articles of association of a company is made more difficult. Okay, so it is made more difficult. How to make it more difficult? So if you want to change it, it may require superior form of majority. Currently, there are two types of resolution. Yeah, he is using the Tamil word astivaram. I use the word foundation. Okay, correct. Now, so Karthik from Coimbatore, which is, I'm also incidentally currently in Coimbatore. No, I'm in a place called Vadavalli in Coimbatore. My daughter is here, my granddaughter and all. So I've come here for a week. I'll be going back to Chennai where I permanently live. Temporary resident of Coimbatore. I have a small house here where I live, just for information, nothing else. Going on. So the point here is, to entrench means to make it more difficult, more protected. Normally, there are two types of resolution. Now I'm going to ask you a question. Okay? At this stage, we will get it done. I want you to put in the query pad, what, in your view, what is special resolution? What is a special resolution? Of course, it is a special category of resolution. Don't put like that. What is a special resolution? When do you say the company has passed a special resolution? So, normally, any clause in the articles of association of a company can be altered by passing special resolution. Normally, when you want to entrench it, then what you will do? You will say clause 14 can be amended only with unanimous resolution. Unanimous means agreed to by all. The minute you say resolution, special or ordinary, we only talk about majority. Whereas, the minute you say unanimous, that means what? All the members should agree. Or you can say 90% of the members, paid up capital, or members holding 90% of the total voting power. Members holding to 90% of the total voting power should agree. This will make it more difficult to change. Okay, that is what. Okay, so beautiful. I'm getting a lot of special resolution definitions, except the correct one. I think I'll get everything. Tushar Sharma, you have not put anything. I'm getting only blank. Okay. Anyway, we will continue with entrenchment. Then I will come to your definitions of special resolution. Now, friends, one more thing. This whole provision is there because it is there in foreign enactments. It is there in foreign enactments. Copycat, they have put it here. No company will do entrenchment. Am I a fool to do entrenchment? Seriously, I am the board of directors of company. I am forming the company. At the time of forming, I will put up for myself. Why I will do? No. Why I will put? I want to alter it whenever I want conveniently. So, maximum you are telling in the act, special resolution. Minimum I will do that. Why I will put for myself conditions? Nobody will put. If you ask me, has anybody come to me and said, Mr. Srikanth, we want entrenchment provision in our articles? Never. Impossible. Maybe some other chartered accountants might have seen. This man was incorporated 2,500 companies till date. Including today, I'm doing 2 companies, as I told you. Nobody has come to me and said, Mr. Srikanth, we want entrenchment provision in our articles. Never. But still the provision is there in the Act. Yeah, I will, Divya, I will show that company. Wait, please wait. I will show. Please wait. Okay. Now, I cannot show you my wife and sister-in-law. I can show only the company. Okay, that too the documents. I cannot show the company also. Can you imagine? Company is an artificial person, has no body, no shape. Okay, I'll show the documents. I'll show the forms. Okay. Chalo. So now the articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures that are more restrictive. So as I told you, instead of special resolution, 90% total voting power should agree. More restrictive, more difficult. So the articles at the time of incorporation itself may have entrenchment, or later on you can amend the articles. But the amendment in the articles for entrenchment, see, currently articles does not have entrenchment. Now you want to make the articles or one portion like Article 14, Clause 14 of the article will have to be entrenched. Example, then it can be amended in the articles provided all the members agree in the case of private company, or in the case of public company, a special resolution is passed. So, your articles do not contain entrenchment. You want to bring entrenchment. You want to amend the articles by which 1 or 2 clauses will become entrenched. For that purpose, for that amendment, if you are a private company, all the members of the company should agree. If you are a public company, then you have to pass a special resolution. I think this diagram is nice. So I'm using this diagram also. Where articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar. Okay? By sending a notice to the registrar. That form I will show you here. That the prescribed form will come in the next slide. So, entrenchment can be at the time of formation, or else you can amend the article, private company, all members, public company, special resolution. Procedure for entrenchment at the time of formation itself means you do it in Spice Plus itself. In Spice Plus itself, you do it at the time of formation. But after coming in existence means you have to file form number MGT 14. If it is a private company, all members should agree. Public, special. Then you will see when you come to management and administration, you will see form number MGT 14 should be filed whenever we pass a special resolution, or whenever we pass a resolution agreed to by all the members. Then we have to file form number MGT 14 within 30 days. Somebody was asking, what is the expansion of MGT? Simple. This MGT 14 form is coming under the topic management and administration of companies. So they use the word MGT, management, that one word, short form MGT. That's what it means. Okay. Now, we already saw that act to override memorandum, etc. Okay. Whatever may be in the memorandum, articles, any agreement, nothing. Whatever is done should be subjected to the act. Act is a supreme. Okay. Any provision contained in the memorandum, articles, agreement, or resolution shall be to the extent to which it is repugnant. Repugnant means unacceptable. Unacceptable to the provisions of this act will become or be void. It cannot be enforced. If act is providing in one way, and the articles or memorandum or agreement or resolution is saying something which is repugnant. Repugnant means unacceptable, not acceptable, okay, to the act. then it will become or be. Okay, become means suppose the law was changed subsequently, then your article still containing old provision, then it will become void. But suppose at the time of incorporation itself, you are putting something in the memorandum which is contrary to the act, then it will be void. But one word of caution here, my dear friends, the memorandum, if it contains anything contrary to the act, the registrar will not register your memorandum. They will ask you to amend it. You understand? That way there is a safeguard. If you have put something which is repugnant, unacceptable, believe me, at the time of incorporation itself, your memorandum will be cleared, not cleared. It will be short. They will say amend it and bring it. You will not amend it. So that control is there. Lokesh, I just now explained MGT now. Did you hear me? I patiently explained MGT. Did you hear me? Are you able to hear me? In case you have heard me, kindly confirm that you have heard me and understood what is MGT. Now, Section 6 talks about Act to override memorandum. This begins by saying, notwithstanding anything to the contrary, notwithstanding anything to the contrary contained in. So the act will have, which means what? Whatever may be said in the memorandum, whatever may be said in the agreement, whatever may be in the resolution or agreement, whatever it is, the act is superior, notwithstanding anything to the contrary. You cannot put it. Okay, you understand? See, suppose you tell me something which is not in accordance with the act. Whatever you may say, it is not correct. Notwithstanding anything to the contrary contained, act is superior. Now, Section 6 begins with the words, save as otherwise expressly provided in this act. Save as otherwise means, except wherever in this act, it is clearly, expressly means clearly, expressly means clearly, without doubt. In words, clear words, it is mentioned that you can have your own way. Then in those cases, the articles or memorandum can have something contrary or it need not comply. If any section of the act says that article can provide differently, then such provision in the article shall be valid. So wherever in this act, clearly, without doubt, they have told your articles can provide differently. In those cases, there can be a contradiction. There can be a difference between act and memorandum and articles. Later on, when we'll see Section 47. Okay. They will say 47 is applicable to a private company subject to its article of association. So 47 normally should be superior to articles. But specifically, clearly, expressly, without doubt, 47 says it is applicable to a private company subject to its article, which means a private company can have something which is different from the articles. Private company ka articles can have something which is different from 47. It will not be violating. Okay. So if private company article says that 47 is not applicable to it, then AOA will be superior because in the act itself they have said it is not applicable to a 47 is applicable to private company subject to articles. So articles itself can say we are not adopting 47. No, you can say. Some cases they will give some minor exemption to private companies. Now, before I go there, let me quickly take up any other doubts that you might have. I'm having 75% or more voting in favor, 75% majority. Resolution for urgent matters. Wow, Monisha ji, wow, great. Urgent matters. So, not urgent means ordinary resolution. Nice try, Monisha. I mean, don't mistake me, but that was a good one. Long time since I heard this type of college level definitions. These are all college student definitions. Special resolution on special occasions. Ordinary resolution on ordinary occasions. I've corrected paper also. in ACS and all, company secretary, some students will write like this. Special resolution is a resolution which is to be passed on special occasions. Ordinary resolution on ordinary occasions. Like that I have seen. Anyway, resolution means resolution by the meeting by shareholders concerned. Or all resolution of members are passed by shareholders. Okay. Yeah, Bhavika Kumari, as I already told you, nobody will do entrenchment. They would prefer to use special resolution and go. Avantika, inter se. Inter se means among themselves. Between themselves. See, between you and me, inter se. Okay. So, the memorandum and articles is a contract. Contract means there must be parties. So, one set is each member and company party. Each member and company party. Then, amongst the members, they are also parties to the contract. So, memorandum and articles are contracts between the member, every member and the company, and also among the members between themselves, amongst themselves. Inter se. That's what it means. I have done my best to explain. Beyond this, I think Hindi, I don't know, I can't explain. In English, to my best, I have explained in simple English. Okay, good. Override, I gave one example, 47. Override means there is a rule, we say that rule won't apply. That is called override. Normal rule is act will be superior to memorandum and articles. 47 is an example of override, where 47 says for private company, articles of association can be superior to 47. Exceptional case where you override. Okay. Normally, I will tell to my staff, please do this, or please don't. Tomorrow morning, all of you should come at 9:30 a.m. sharp. That is the rule. Then one man alone says, sir, I have this issue, sir. Okay. For you alone, override. In your case alone, you can come at 10:30. Exception is created. Okay. Okay. Thank you, Mansi ji, for accepting that I have good knowledge. Okay. Thank you for that nice words. I mean, these small words, make me feel happy. That's all. So many of you who are here, because I'm again using age, I don't know how old, but I'm assuming the average age of people here would be younger than my daughter. My daughter is now 30, I think, 29, 30. My son is an advocate, he's 25. My daughter is 30. So many of you here, I think, are younger than my son and daughter. Daughter at least, if not son. Even son. So think about it. You're all younger than my son and daughter. Quite young, some of you must be, 18, 19, 20, like that. And so as I grow older, I realize that the students are going, the age is going away from me. But my guru, Professor K.S. Anantharaman, at the age of 85, he used to teach students who were 18 and 19, 19, he used to teach Contract Act. So whatever it is. Anyway, later on, I'll introduce my teacher to you by photo, a great man called K.S. Anantharaman. Later on, some other class on the right occasion, I will introduce my teacher to you. Okay, thank you, Divya ji, for all those nice emojis. And let's hope. Okay, chalo. Good, moving on. See, the special resolution, none of you is aware. So I'm not going to teach now because it is going to come in management and administration. In the meantime, you go to your own Board of Studies ka material. There you go to the chapter on management and administration. There you locate special and ordinary resolution. This is a homework. Don't do now. Abhito, no. Don't do it now. Do it when you are tomorrow, later. When before the next class possible, please. I don't want to tell you. If I tell you, it's one thing. If you do it yourself, you will remember better. So just to go there and read. What is special resolution? What is ordinary resolution? In the institute ka material. That is your golden Bible, na? That book you read. Don't go anywhere else. Don't read. Even don't go to the Ministry of, don't go to the Companies Act, Bar Act. Normally, I will ask you to go to the Companies Act, Bar Act. No, don't do that. For you, Board of Studies material is God. Go to that material. And in that material, you take management administration. There you go to special and ordinary. Please check. What is the definition? By next class, all of you should be thorough in special resolution and ordinary resolution. But I will teach in the next class a little bit. But before that, you read. Then the minute you read, you say, like that. And then you will remember it. And never ever you will forget it. Okay? Okay. 22. What is 22? I don't know. Section 20. No, I don't think it's section. I think it's some 100. I forget section. Yeah. I think 112 or something. I don't know, ma. Seriously. See, once upon a time, this fellow used to know. I'm not joking. Under the old 1956 Act, more than 250 sections, 250 sections ka content I used to know by heart. Content means almost all the important sections in the Companies Act I used to know by heart. Meaning, I'm talking about 1990, 2000 and all. I will just enter the class without any book. And I will start dictating the notes. My students will be having the Bare Act book and all. So I will be dictating. From memory, I will tell that section. And the number and all I will know. That was in the old law. So now this new law, I am not able to remember section numbers. The logic I am clear. But I am unable to give the exact wordings. Two reasons. One, the old law, the English was superb. Now the English is bad. So I am unable to memorize this bad English. One. The old law, it was a beautiful law. And many good things in the old law, they have removed it. The wordings and all, they could have. Anyway, so I used to know, but now I am not able to remember. In those days, I used to remember. Chuck, I will tell the section numbers now. Now I am not able to remember. No problem. But if I think it's 112, I may be wrong. But you can easily locate now special resolution, ordinary resolution. Okay. Just you can go and you can see. I'm not going to teach you now because if I do that, time will be wasted. Next class, yes. Depending on my coverage, I will spend about 10 minutes on special and ordinary. Why? Because from now on, every topic you will find the word special resolution is used, ordinary resolution is used. Everything procedure means past special resolution. So you should know what is special and ordinary. Thank you, Ms. Gunjan. So nice of you, Mr. Gunjan. Thank you. Good. Moving on. Coming to the topic again. The memorandum and articles shall, when registered, bind the company and the members. Are you able to understand? So the company is bound to every member. Bound means tied. And each member is bound to each other. That is what it means, inter se. I am bound to the company as a member. I am also bound to all the other. So that means what? If there are 7 members, you do the math. Okay, how many? Permutation and combination. But that many contracts are there. So A, B, C, D, E, F, G, H, na? A with B, A with C, A with D, A with G, like E, F, G, like that, each one. Got it? So many contracts are there. That is what inter se means. There is a contract between each member and the company and members and the company. So on the basis of MOA, company is bound to members, members are bound to company, members are bound to each other. Okay. So although MOA and AOA constitute a contract between members inter se, normally members are not liable to each other. That is individually nothing. But we are commonly tied to obey the articles and rules and regulations of the company. See, this is called whenever you become a member of any body, whether you become a member of a company or whether you become a member of a residential welfare association or whether you become a member of a society or a club, whatever, or Rotary Club or Masonic Lodge, the minute you become a member, you sign that application form and you give it, you are agreeing to be bound by the rules and regulations. You cannot act contrary to the rules and regulations. Also, you are agreeing to respect the rights and privileges of the other members. That's what it means by binding. So, everybody has unique right. So, your right is subject to my right. You cannot have a superior right. That is what it means inter se. So, when we attend the meeting, every member of a company has the right to receive notice, to attend the meeting, to appoint a proxy and vote on his behalf, to vote by post, to vote on an electronic e-voting. These are all rights. To get dividend in case the company is wound up to receive the money. That's all. These are the rights of a member. Beyond this, you can think of some rights, but very, very few. Okay. On any matter, you have the right to attend the meeting and vote. That is one important right you have. That right to vote is a collective right. You cannot exercise it sitting at home. It has to exercise only at the meeting. Either virtual or postal or physical, you have to attend and vote. You can't sit at home and write a letter and say, according to me, you guys have to do like this. Nobody will respect it. Go to the meeting. Present your point. Finally vote. Majority member will decide. Whatever the majority decides is final. In some cases, they say ordinary is not enough. We need special. That's all. Okay. All monies payable by any member to the company under the memorandum shall be debt due from him to the company. Mainly what? If there is any COL, suppose the company is having partly paid shares. Any amount due under the memorandum shall be a debt due from him and can be collected as such. Okay, later on when we come to share capital and debenture, I will also say for these type of debts due by the member to the company has a lien on the share. Lien means right to retain possession. So if that debt is not cleared, the company can refuse to register transfer. They can say, no, we pay the debt, then only we do. The MOA and AOA create contract between the company and its members, and the members inter se. But a non-member, such as a director, has no right to sue under the MOA or AOA. Many of you may have a doubt. Is a director automatically a member? No. A person may be a director, but not a member. A member may not be a director. They are alag roles. A person may be both member and director, but different roles. Are you able to understand what I'm saying? Different roles. As a member, he has certain rights. As a director, he has certain rights and duties. You understand? Don't confuse. So, memorandum and articles are only applicable to member. Director, in that sense, is not a signatory to the memorandum. He cannot claim anything under the memorandum and articles. Company secretary, no. Advocate, no. Even though their name may be mentioned in the articles, they have no privity of contract. Privity. Privity means they are not a party to the contract. So non-member cannot claim. For that, there is a case law also, I will tell you. Okay. So the articles of a company contained a clause that on the bankruptcy of a member, his shares should be sold to the other shareholders at a price fixed by the directors. Okay. So in case of bankruptcy, bankruptcy means insolvency. Insolvency, bankruptcy means that member is not able to pay his debts fully. In those cases, his shares should be, see what happens when a person becomes bankrupt, his assets have to be sold. One of the asset is his shares in this company. So the receiver or assignee, like the liquidator, that receiver or assignee will be responsible for selling the assets and paying the liability. Such fellow will want to sell the shares now. This articles of this company has a clause that says, in case a member becomes bankrupt, his shares should be sold to the other shareholders at a price fixed by the directors. This is the articles. B, when he became a member, he agreed to it. But later on, he became bankrupt. His trustee in bankruptcy, that is the receiver or assignee. In India, we call receiver or assignee. That gentleman claimed that he was not bound by these provisions and that he can sell those shares at the true value. Be careful. In this case, the total thing is, who is B? B is a shareholder. Till his death, he was a shareholder. After he died, the right and duty continues. So anybody who is claiming under him is also bound. See, the trustee was bound. Share was purchased by B upon the terms mentioned in the articles. Now, Because the trustee has taken over, he will not become third party. He is only representing B. The receiver or assignee, the trustee, even suppose B had died also, the legal heir is only representing B. So whatever rights and duties B is having, the legal heir or the receiver will have. So if the articles are saying this is how it is, that is how it should be. This is the decision given in this case, Borland's trustee versus Steel Bros Company Limited. I am giving you some case laws. This may not be there in the Board of Studies material. Similarly, I may not discuss some case laws which are there. Kyonki, simple, because it is there. Why should I again put it here? You can read it there. Now, this is another case where the articles of a company provided that Eli should be a solicitor for life to the company and should not be removed from office except for misconduct. So the articles are providing that Eli, one man's name, should be a solicitor for life. But remember, who is signing it? Only the signatory to the memorandum. They are bound by it. Who is Eli? Eli is a third party. Later on, he also became a member of the company. But after employing him as a solicitor for a number of years, the company discontinued his services. Now, this fellow Eli, being a member, sued the company for damages for breach of contract contained in the articles. Please remember, Eli has two roles. One, Eli the solicitor. Another, Eli the member. Now, which right is being affected here? Eli the solicitor's right. Whereas as a member, nothing has happened. In fact, as a member, he is bound by the articles. Now, what does the article say? Eli should be a solicitor for life. Okay? But Eli cannot sue. Are you able to understand? Even if he is a member, he cannot sue for breach of contract. What breach of contract? As a member, there is no breach of contract. As a member, what are his rights? I told you, attend the meeting, vote, receive dividend. That's all. If there is a breach in that contract, he can sue. But the articles had a clause which says he will be solicitor for life. That is breached. He is a third party. In that sense, he is a third party. I am giving these two case laws so that you will understand the contrast. When B died, still the membership status continues. But here, from the beginning, Eli is a third party. When he became member, he got certain rights as a member. But those rights are different from the rights as a solicitor. So this case was dismissed on the ground that Eli, as a solicitor, was not party to the articles. See, as a solicitor, please understand, as a member he is, but as a solicitor, he is not party to the articles. I want you to clearly understand difference in role. So a man may be director, whichever right is affected, only you can sue. Suppose your right as a member is affected, you can sue. But here the right as a solicitor is affected. So he is not party. As a solicitor, he is not a signatory. So this rule will apply. Non-member has no right to sue under the MOA. Eli is a non-member. This was decided in Eli versus Positive Government Security Life Insurance Company. So some of you may be wondering why I have put this small photograph here. Why this photo is here? Some of you may not, may be aware. Some of you would understand why that photo is there. But some may be wondering why that photo is there. Photo of your mouse is there like that. So there's the problem with language. Okay. There's a problem with language. One word in one language may have another meaning in another language. Okay, now. Ultra vires. Now we go to the doctrines. What I will do is, before we go start the doctrines, we will have a small break for 5 minutes. Okay? Small break for 5 minutes. Sir, break, sir.
Okay, welcome back from your well-deserved break. Let's continue because time is really a big thing, but it's okay. No problem. So we are going to go to the doctrines. Doctrine means rule. That's all. Doctrine means rule. R-U-L-E, rule. Rule. Big term, doctrine. Doctrine of ultra vires means rule of ultra vires. Already I mentioned, ultra means beyond. Vires means power. So beyond the powers. The opposite term for ultra vires means intra vires, mean within power. Intra means inside, within the powers. Okay. So when a company or its directors violate the provisions of this act or any other law, such an act is unlawful and it attracts penal liability. I told you, an illegal act. This act cannot be ratified even with the consent of all the members. Okay. But unless it is illegal, okay, other than illegal, when the directors exceed their authority, the company may ratify what the directors have done. Okay. Normally, see, suppose, as I told you, they have done something which is within the articles. They have, for example, they should not borrow 1 crore unless beyond 1 crore, unless they have got permission from the members. Now, members can ratify this because it is within the scope of the memorandum. But suppose the directors do something which is beyond the scope of the memorandum, meaning it is not covered in the objects clause. It is, they have entered into a contract or borrowed money for a purpose which is not mentioned in the memorandum. Suppose the company is formed for manufacturing steel, okay, or any metal, ferrous and non-ferrous metals, metallic metals, manufacturing and selling, exporting metals. These fellows have entered into a contract for construction of a hotel. Now, this is not in the memorandum at all. The memorandum, objects clause of the memorandum says to manufacture, deal, trade, buy, sell, export, import, or otherwise deal in all types of ferrous and non-ferrous metals. This is the memorandum. There is nothing mentioned about hotel, whereas these people have done it. Now, even all the shareholders cannot ratify this because this is beyond the scope, beyond the powers of the members. It is ultra vires the memorandum. So, such an act is ultra vires the memorandum, is void. So, an act which is done, which is beyond the scope of the memorandum, is void ab initio. This was laid down in a, you must also do a little reading from your Board of Studies material. I will explain the doctrine. Do the detailed reading, you do it there. This was laid down in a very famous case. Okay, it's a famous case. You should know that case law if you can. That is called Ashbury Rail Carriage versus Riche. Let me do something. I will type out the doctrine here. An act which is beyond the scope of the MOA is ultra vires, and therefore void ab initio. Ab initio means it is void from the beginning. It is void from the beginning. Okay, it was never the same. Do you remember when you studied Contract Act long ago? I do not know how long ago. When you studied Contract Act, they told you acts done by a minor is void ab initio. Means contract entered into by a minor is void ab initio. Am I correct? That was
where capacity to contract. You studied it under capacity to contract. And you said minor has no capacity to contract. Therefore, any contract entered into by a minor is void ab initio. See, you cannot prevent a minor from entering into a contract, but such contract is void ab initio. In the same way, for the company, see, company has no age of majority, minority, but company has a memorandum, object class. That very clearly says what the company can do. Negatively, it knows what the company cannot do. Now, any contract which is entered into, which is beyond the scope of the memorandum, is ultra vires. The company does not have the capacity to enter into the contract. Therefore, it is void ab initio. Are you able to understand this? This dictum, this decision, this view was strongly laid down in a case, Ashbury Rail Carriage Company Limited versus Riche. See, in Ashbury Rail Carriage versus Riche, this company was incorporated for manufacturing railway carriages. But this company in Belgium, they entered into a contract for laying railway track. They entered into a contract. See, maybe they had the knowledge, etc. But the memorandum did not mention that. So, they only talked about manufacturing railway coupes. That is railway, like our ICF and integral coach factory, like that. Okay. So, that is the thing. Chittananjan Bihana, where we manufacture coaches. I see integral coach factory. We manufacture railway coaches. So, this fellow was supposed to manufacture only railway carriages. They entered into a contract for laying railway line in Belgium. For that, they entered into contract with this fellow Riche for some coal, etc. Now, the case came. The company, obviously, the company went into liquidation. At the time, the liquidator told these contracts are void because it's beyond the scope. The memorandum only talks about railway carriage, whereas this is for laying rail. Riche was a poor fellow. He went. See, this case is Ashbury Rail Carriage Company Limited versus Riche. This case was going on and on. First, this fellow had gone to Chancery Division in England. He would have filed a case. Then he goes to Court of Appeal. Okay. Or maybe the company goes to Court of Appeal, Riche wins. Then it comes to the House of Lords. See, in England, that is how the appeal will happen. First time the case will go to Company Court, which is Chancery Division, Company Court. Then from there, it will go to, if somebody is not happy, then they will go to the next step, Court of Appeals, where again judges will be sitting. Finally, it will go to the Law Lords, the House of Lords. Okay, they will form 3 lords, 4 lords, a bench will sit. In this particular case, a famous judge, his name was Lord Macnaghten. In fact, I've read the original decision. The original decision is available. I've read it. My guru, Professor K. Santraman, made me read all the original British cases. In the original decision itself, fully I have read. Wherein Macnaghten very clearly said, that is why this is a very famous case. All the shareholders cannot ratify an act which is beyond the scope of the memorandum. In the same way that a minor, cannot ratify his contract. Because Baba, minor cannot be a principal, ma. See, suppose when you are an agent of a minor, you are gone. Because that fellow cannot ratify. Huh? So the contract is void ab initio. He cannot ratify it also. So, like that, this has to be done. So, yeah, these case laws you would have studied in foundation. That is why I'm skipping it. But now in your Institute ka Board of Studies ka material, I'm finding they are dealing elaborately with this. So my humble request is you read it. They may ask you a question on doctrines in the exam. They will definitely not ask you what is the doctrine of ultra vires like that. No. Rather, they will give you a case law or some problem and ask you what is the decision. So remember, anything done which is beyond the scope of the memorandum of association is ultra vires and therefore void. Now, why is this like this? Because ultimately, who is the sufferer? Please think. In fact, my guru in his book, he says, this is a trap for the unwary third party. This is a trap for the unwary third party, meaning a third party who is not aware, this becomes a trap. Okay? So, why is it like this? The idea is simple. Sir, when I invested in this company, Ashbury Rail Carriage, for what purpose I invested? My knowledge, my thought was that this company will manufacture railway carriage. Now these guys are investing in railway track without my knowledge. See, are you able to understand? What they should do? They should call the members, amend the memorandum. They should amend the memorandum object class, change it. Then, with the new memorandum, please enter into contract with Rish, nothing will happen. But with the old memorandum, if you enter, I am a shareholder who gave me money for the rail carriage. Whereas you are doing. See, this is not very difficult to see. You might say, sir, what is the difference between rail carriage and tracks are like that? You are right. Whereas, suppose there is a company, startup company. They are saying we are into digital, artificial intelligence, blah, blah, blah. I believe all that. And I give my hard-earned money to these donkeys. 2 months later, these buggers enter into a contract for construction of hotel or real estate, infrastructure development. Hey, I didn't give my money for infrastructure, Baba. Your memorandum very clearly says digital, artificial intelligence. What right you have to take my money and use it for that purpose? So it is meant to protect the investors so that they may know for what purpose their money will be employed. Also, it is to protect the creditors, because when the existing creditor, not the new one, the existing creditors, when they lent the money, they clearly thought this is meant for this purpose. Now you are changing. So in order to protect them only, this doctrine is there. Okay. Now, so who should be careful? Now remember the doctrine of constructive notice. What does it say? Any document which is public is available to you. You are deemed to have read it. Hello, Mr. Rish, come here. Why you didn't read the memorandum? You are uneducated or what? Can you not read the memorandum? No, I didn't read it. Sorry. Even if you have not read it, doctrine of constructive notice says you are deemed to have read it. Now you cannot come and cry. Please go. Like that, Lord MacNaughton has told Rish and sent him. Okay, this is the essence of doctrine of ultra vires. So whenever in a problem you see what is the object class, this contract. If there is no connection between the object class and the contract is ultra vires void ab initio. Simple. So we already talked about competency to enter Indian. I've already covered that, so I will not waste. Oh, I've given here, yeah. The corporate life cannot be spent for any purpose other than those specified in the memorandum. This is again a golden words of Lord MacNaughton. Lord M-A-C, again capital N-A-H-T-E-N, MacNaughton. Famous judge, Lord MacNaughton. Denning, of course, Lord Denning. Famous editions are there. Okay. Now we have to move on to constructive notice and indoor management. To understand constructive notice, so to understand indoor management, you have to first understand constructive notice. Already seen. Deemed knowledge. It's a rule of presumption. Deeming. A third party proposing to deal with the company has read all the documents filed with the ROC. Yes, he has read it. Yes, fully read it. Pattaya. He has read it. Not Pattaya. Pattaya. Okay, Pattaya is in Thailand. This is Pattaya. Therefore, he is expected to know what the company can and cannot do. He cannot later plead ignorance. So, doctrine of constructive notice is the basis for ultra vires. Meaning, third party is deemed to have knowledge. He is supposed to have read the memorandum, knowing if he enters into a contract which is beyond the scope of the memorandum or articles, that
contract is void. Of course, if slight difference is, suppose it is contrary to the articles, the members can ratify. But if they refuse to ratify, third party gone. You understand? If the members keep quiet, then third party gone. But if the members are willing to help the third party, what they can do? If it is only violation of articles by the directors, the members can say, chalo, these directors, rascals, they've done it. We will ratify. But if the members refuse to do it, gone. That also is void only. Third party is gone. But sometimes, members will oblige. The directors will say, sorry, we have done like that. Please, we hold a meeting. Kindly pass the ratification. Chalo, get out. Because ultimately it is beneficial to me. See, when I will ratify, when a principal will ratify, when it is beneficial, I will ratify. But when it is not beneficial, I'll say, go to hell. Am I correct? See, suppose whatever Ramalinga Raju did, finally he was able to correct it. And he was able to come out of the problem. All the fraud done by him, we would have blessed him. Because he has saved. But it's because, the crime here is that Ramalinga Raju could not succeed in his fraud. Successful frauds will never get caught. Ramalinga Raju's fraud was not successful. But in the long run, my dear friends, no fraud will be successful in the long run. We can cheat some people some of the time. Okay? Some people all the time. But we cannot cheat all the people all the time. Are you able to understand what I'm saying? So, fraud is always dangerous, bad. Never do it. Now, doctrine of constructive notice you have understood. Now come to doctrine of indoor management. A transaction may have two aspects. Substantive, what has to be done, and procedural, how it is to be done. Substantive, what has to be done. Procedural, how it is to be done. So, an outsider may have presumed to have knowledge of both substantive and procedural aspects. See, you are learning procedure now. You know this has to be done. Special resolution has to be passed, etc., etc. Board resolution has to be passed, etc., etc. You have knowledge of what the procedure is. But can you find out whether the procedure has been actually complied with? I don't think so. How you will do? Because you cannot do that. If you want to do that, you have to go indoor. Are you able to understand? See, my house is, I lock the door, I go in, you can't come in. Inside the house, I do something, I come and tell you we have done it. You have to believe me. So long as I show document, you have to take it for granted. So third party has a duty to read the memorandum and articles, to know what is the substantive, what is the procedure. So substantive says company can enter into a contract for the following purpose. Construction of this, that, done. So to borrow money, the company should pass a special resolution, done. That's all. Procedure also known. Now I can go to that guy, directors, and say, hey, have you got special resolution passed? Hanji, Hanji. So show me the proof. So they give some paper, kagas mein certified, some company secretary has written certified true copy of extract from the meeting, minutes of the meeting of so-and-so company held on so-and-so date, blah, blah. Then signed, certified true copy, signed so-and-so. I have to take that paper, Baba, keep it safely, that's all. Beyond that, I cannot do. Maximum what I can do, that gentleman who has signed it, now his sign I can compare, whether it is the same guy. Even then, suppose that meeting was never held, how do I know? Suppose the resolution was never passed, how do I know? So, third party can presume in his own favor that things which ought to have been done regularly have been done regularly. Whatever you say has been done, okay, it has been done. Therefore, I have to agree. I cannot go beyond that. This is known as the doctrine of indoor management. So, in a way, constructive notice says you are deemed to know. Therefore, if you have not known, it is nobody's problem. If it is beyond the scope, void. Now, indoor management says, I am deemed to know and I am aware, but if it has not really been done, I am not affected. You understand? Special resolution has to be passed. I know. I have read the articles. I call the directors. Have you passed? Yes, sir. Give me proof. Yes, sir. 3 bags full, sir. Over. After that, if these directors, buggers come and say, or the members come and say, or the liquidator comes and says, that resolution was never passed, blah, blah, that is not my problem. Because to find out whether that resolution has been passed, I have to come indoor, not INDORE, but INDOR, inside your house. I have to cross the door, which I will not. I am a third party. I need not. Okay. So this doctrine was first laid down in the case of Royal British Bank versus Turkand. Turkand is England and France were once upon a time single. Many of you don't know this. It got separated post World War II. That is, there is a place called Normandy, okay, which is partly England, actually. Okay. So that, that Dunkirk and all, that area was originally English. Then there's always a fight between French and English on that. Okay. So, in fact, there are many English-speaking people in Normandy during the world, not the World War I and all, even during the War of the Roses, there was a big fight. And Henry V and all went all the way up to France, conquered France, came back. Then again in Henry VI, by the time Henry VIII, everything gone. By the time of Victoria, England is separate, France is separate. But once upon a time, England controlled that much. Okay. So you will see a lot of French names in English cases. So Royal British Bank versus Turkand. The doctrine of indoor management is also known as Turkand's rule because it was laid down in this case law. Okay, famous case law. In this case, what happened? A company had powers to borrow money provided a proper resolution was passed. The company borrowed money and issued bonds. But the resolution was not in fact passed. But it was said the company was bound. See, the bank was bound, that is the Royal British Bank, was bound to inspect the articles, which it did. Beyond that, they were neither bound nor entitled to look. Otherwise, it would take them indoor, that is behind the closed doors of the company's boardroom, right? In fact, this actual name, this word, indoor, was used in Mahoney versus East Holliford Mining Company. That case law only, the word indoor was used. Mahoney versus East Holliford Mining Company. Okay. Now, some of you might already have a doubt. Sir, should I know case law, sir? Try to remember a few case laws. Try to remember a few case laws. Not all. See, in fact, this word indoor was not used in Royal British Bank. It was used in another case called, I don't know that, citation. In your Board of Studies material, you will find some citations are given in the bottom. Whenever they cite a case law, they'll put a small superscript number. If you check that number in the bottom of the page, you will find one citation will be there. Don't remember all that. Please don't waste your time. See here, you can see 1856, 6E and B, 327. Don't. See, this is one thing is there now. This case was decided in which year? 1856. Are you able to understand? Victorian time. 1857, Victoria became the Queen of India. Do you know that? Till 1857, the East India Company was not ruling us. They were simply coming and doing trading. But by then, and the 1857, the first war of independence, the British were really affected. They were literally thrown out, especially Nana Padnavis, Nana Sahib, and all that, Jhansi Rani, they literally, almost they were destroyed. But they came back with full power and they completely conquered. And at that time, the Queen Victoria said, from now on, you are my subjects. Okay, that is 1857. You can check out. If you have a doubt, you go to Kolkata. Those of you are from Kolkata or nearby, or when you go to Kolkata, don't miss going to the Victoria Memorial. There inside the memorial, you will see Victoria's message to her Indian subjects. Of course, as an Indian, we feel angry, but also somewhere, I feel, see that lady, she had so much kindness towards us. See, that slave mindset has not gone. But when I read that, Victoria will say, you are my subjects. I will take care of you like that. And all. He said, wow, oh, madam, thank you like that. See, that mindset is not going. What to do? Anyway, Mahoney versus East Holliford Mining Company Limited. That's also another case law where this doctrine was better laid down. Okay? It's better laid down.
So all rules will have exception. First, you should know the rule. Then only you can understand the exception. Okay. What is the rule? I am a third party. I am a third party. I am aware of what is to be done, but I cannot be aware whether it is done. I am a third party. I am aware of what has to be done, but how can I know whether it is done? I cannot. Therefore, every exception will be one where I am not a third party. Are you able to understand? Where I am one of the directors, or I am a person having knowledge of the irregularity. How can I say I am a third party? I am not aware. I am aware. The fact is that I am aware. For example, in Morgan versus Canson, Morris versus Canson, two directors. Okay, one was not a director, the other was a third party, the one was a director. Together they had a board meeting. They appointed Morris as a director. Now Morris is acting as a director. Later on, when the case was filed, Morris says, I am a third party, Doctrine of Indoor Management. But the court said, hello, how you are third party? You are part of the, you are acting as a director in the transaction. What they did was, this Morris and other people, they allotted shares to Canson and all. They allotted shares. Then they did fraud. Then Morris was sued. At that time, Morris as a director said, hello, my appointment is not valid. I am a third party. How I know about all these things? Like that. I didn't know that they are not directors. No. You acted as a director. How you can now say, I am a third party? You are not a third party in this matter. Okay? That's what it now. So I think what happened, the two directors, one was not a director and the other was a director. Together they appoint Morris as a director and they allot shares to Morris. Then later on that becomes void. Then Morris files a suit and he says, I am a third party. Therefore you have to give. Court said, you are not a third party. You are well aware that these two fellows are not directors when these shares were allotted. So how can you say you are not a third party? You are a third party. Similarly, person having knowledge of the irregularity. See, board of directors, a company had an articles which said, this is Howard versus Patent Ivory Company Limited. Howard versus Patent Ivory Company Limited. In that case law, the directors were, the articles are very clearly saying up to some 2,000 pounds, directors can borrow. Beyond 2,000, resolution is needed. Now the directors are lending money without getting the special resolution. They want to claim. The court said, no, only up to 2,000 pounds you can claim. Beyond that, you are unsecured, you go and wait in the queue. Why? Because you are a director, Baba. You cannot say, I'm a third party, I'm protected by indoor management. Okay? You are a director. You are having knowledge of the irregularity. How can you say you are? Similarly, where the act done is ultra-vires the company itself. See, illegal act, ultra-vires act, no indoor management. It is void. Something which is void cannot be given life. Forgery. This is persons, where a person, see, this will especially bank. Later on, when you come to Negotiable Instruments Act, remember, the paying banker, when the check is presented to the banker making the payment is under a greater responsibility. Not simply, he cannot say, I'm a third party and all. In one case, what happened? The company secretary forged the sign of the MD and he deposited. Now, the bank simply passed it. Said, hey, how can you do this? You are the banker. Should you not compare the signatures? A forgery is a nullity in law. When you have accepted a forged signature, you are a negligent. Now you cannot claim indoor management. So, especially bankers, even others, when you have a doubt, you should be sure that the signature is that of that person. If you have not made that verification, this is a normal negligence. You cannot be protected by the doctrine of indoor management. Maybe I'm talking a little fast. I'll go a little slow. Persons put on inquiry. This is negligence itself, where one MD of a company, he was continuously, endorsing the checks payable to the company in his name and depositing in his account. Not one check, two check. All the checks, every check in the name of the company, endorsed by the MD to himself, deposited in his account. Now, the bank should be put on inquiry. Put on inquiry means a reasonable person will call, hey, Mr. MD, come here. What are you doing? How is it? Are you got any authorization for this like that? Without asking if they are passing these checks and crediting the account, it is a negligence. It's called persons put on inquiry or negligent behavior. So these are all exceptions to the doctrine of indoor management. Now, my dear friends, in the doctrines, how they will ask the question. If at all they are asking, they may ask you how they will ask. They will not ask you theory question. Impossible. No. They will give you a problem, situation, and they will ask you to decide whether the claim given by this person is right or that person is right. So, go to the institute material. There are a lot of questions at the end. Go through those question and answer. You will be able to understand better. If possible, I will also cover a couple, if possible. Because today, I don't think I can cover this topic. It's too large. See, there are 141 slides, whereas I'm now only in 103, which means I can't do it today. That's why I'm going a little slow only, and I'm going for covering one more class. In the meantime, if you are, some of you are very particular, I will upload this slide. Even after making verification, if the banker didn't find us, what will happen? Sir, bankers, you check out, they have that signature specimen. They see the specimen signature is with them. So that has to be compared with the specimen. Today, computer is comparing. The check is scanned and the signature is already there in facsimile, in scanned image. That is why artificial intelligence has come. But in those days, many bank clerks were trained to, find out. If they still pass the forged check, the banker has to repay to the company. Banker is bound, liable to the company only. Yeah, because, see, there, it will be a big drawn-out case in the court, where the bank will say, there is no way we could have known that this is a forgery. So, handwriting expert will be called. Then he will compare the two signatures. If there are many differences, more than 7 or 8 differences, then the banker is liable. But if the signature is beautifully forged, artful forgery, then maybe the bank will have a chance. But that is not for you and me to decide. It is for the evidence and for the court. So don't worry. Normally, forgery will be immediately captured. See, by looking at it, you can say, hey, this is a forgery. See, nobody can sign another person. What they usually do, they will take a tracing paper and they will trace the signature. Then, using the same tracing paper, with pencil, they will write on the tracing paper on the check. Then, with the ink, they will follow that hollow, that thing. That's how the forgery will be usually done. Easily. Because when I'm signing now, I will sign with speed. But when this man is copying, definitely there will be stoppages. Ink flow will be different. See, with a good calligraphist, can easily find out. And at a glance itself, it will be known. Even if slightest doubt is there, the banker should refuse to pass the check. He is entitled to refuse. He can say, refer to drawer and take it out. He is entitled. Okay? This is the general law. So, now we move on to alteration. Okay? Alteration. Alter means making of additions, omissions, and substitutes. Then, why you didn't use writing facts by yourself, like giving written notes? I don't know. In those days, again, Mr. Sarvanshu, I'm not able to understand your question. Why you didn't use writing facts by yourself, like giving written notes on live section? I don't know. In those days, my book was not there. Subsequently, I think 2009 or 8, my book came. 7 or 8, my book came. My book for final came. And so that book I used to use. My book will be given to all the students and they will keep it. Then based on the book, I used to teach on the board, with board. No PowerPoint. Live classes. Later. Then after some time, I think 2005 onwards, 2004-5, I started giving Xerox notes. My notes will be Xeroxed and given to the student. Then my book itself came. Then once my book came, the institute will, not the coaching center will give my notes to the books to the student will. That way, my book used to be used by many people. across India, even many students from Andhra Pradesh. In fact, I have one gentleman here, Mr. Megansh Bharadwaj. If he's still online, good. Otherwise also, he says, I was a student of batch 6. That is not this batch. You are batch 1. Before that, batch 7. Before that, there was a batch 6. So he was a student of batch 6, means 22 ka. And I attended your class of law. Thank you, sir, for sharing your knowledge with us. And it was due to you that I cleared my group in first attempt. So congratulations to Megansh Bharadwaj. And this is not to boast or to say, see me. Just to, I'm happy that, one person is confirming that. I'm so happy. When I hear that students are clearing the exam, I feel so happy. Okay. And that happiness is something, it cannot be replaced by money or by wealth or by assets or by one more car if I buy. I cannot get that happiness which I will get when I read Megansh's comment that he has cleared first attempt, that group. So I wish him all the well that he should become a member of the institute. See, third party does not ask for ordinary result which needed to be passed. Will it fall under negligence? To an extent, yes. To an extent, yeah. Once you know that a resolution should be passed there, that is why I'm saying now, later on, Mr. Rito Banerjee, suppose you are working in a bank, is a credit officer, and you are going to sanction your loan to a company. Abba, be very, very careful. Get the memorandum, read it, see whether this money will be used only for that purpose. Also, if there is any resolution to be passed, get document, everything you get it, make a company secretary, do a search and get all the documents, then let him give you or you satisfy yourself, and then put all the paper in your file, and then only you should sanction. That way you will never get into this. Okay, now moving on, alterations. So let us go to alteration. Today I said I will show you that thing now. So let me do that, because that is, then some people may think I told you and then I have not done it. So I will show you. See, this is the company. What happened was, my original company ka naam was Blue Dot Consulting Solutions, right? Okay, then I wanted to change the name from Blue Dot to Prometheus. The name of the company, I wanted to change it from Blue Dot to Prometheus. Okay, so this Blue Dot I wanted to change to Prometheus. Prometheus Consulting. So this is the certificate of incorporation given by the registrar for the change. After we complied with all the requirements for the alteration, the ROC Chennai has given the certificate. So herein he says the company was originally incorporated under the name Blue Dot Consulting. And this is the address of the company, etc., etc. So for that, later on, you'll be seeing, we have to file form number INC 24. Okay. This is the online form INC 24. You have to fill up. It will be online. You can download the form, the HTML, and you have to file. You have to fill it. And you can fill it in all these things. Everything is fact. What is the new name you want? Before I can get this name, first I have to get the name approved. Same procedure. Same procedure. Okay, I have to go to the website. I have to go get the approval and come. Then, once the name is reserved, within 20 days, I have to go for change. So, I have to pass a special resolution. In this case, that is why you will see one more thing is there. In this case, this is the form. Then this form, along with that, MGT 14. Why MGT 14? Because we are passing a special resolution. So, it will ask, what is the date of dispatch? What is the rate of passing? You will notice that the gap between the two, okay, is less than 21 days, which is why we would have also got approval from the shareholders. Okay, so you can see now, shorter notice consent we have given. These are all the list of attachments. Whatever you are going to attach, that document we have to mention here. Okay, as and when you attach it, it will get listed here. So that together, along with the attachment, it will be. So what are all the attachments? EGM, memorandum of association, article of association, shorter notice consent, everything is here. So these documents are all there. Then there is a declaration and all to be digitally signed by the director as well as by the company secretary in whole time practice. So this is the notice to the shareholders. See the resolution. The name of the company will be changed. B and is hereby given to change the name of the company from Blue Dot Consulting to Prometheus Consulting. So this is the resolution copy. This is signed by my wife, who is the managing director of this company. Okay. So she is signing everywhere as true copy. Okay. So she is signing everywhere as true copy. Okay. Now, so this is the notice. Okay, this is the notice. Maybe later on, in case I'm teaching management and administration, I will use the same document to show you how a notice should be given. What are all the statutory information to be provided in the notice? Member entitled to attend and vote can vote through. All this will be relevant when you come to management and administration. Okay. I just want to also show you the memorandum and articles itself. Okay. Which is what I said I will show you. This is the map of the address, registered office address. Okay. So on and so forth. See, I told my sister-in-law, no, actually it is my mother who is one of the shareholders. My mother, who is no more, she passed away in May. She is one of the... Then late, after my mother's demise, only my sister-in-law became a director. Okay. Now, my wife's sister, is she a relative under the Companies Act? Sister-in-law, my wife's elder sister, is she my relative under the Companies Act? Okay. Now I just want to show you the articles. Quickly, I'll scan through this. I can even share this with you. There's nothing secret about this. I can even upload this. As I told you, this is a public document. This is the declarations given that they have correctly filed financial statements and all that. This is the memorandum of this company with the changed name, with the new name. Okay, new name. So name clause is there. Then second, the registered office of the company will be situated in the state of Tamil Nadu, Chennai. There's no need to give, but they are giving. I don't know why. Tamil Nadu is enough. Then the objects. So only these three objects, main objects. 4, to conduct training programs and all that. Okay. To give consultancy. So this is the restriction. This company cannot do anything beyond this. This company cannot start manufacturing automobiles. No. This is the restriction. It's a service company. Okay. These are incidental objects or objects which are necessary for the main objects, like borrowing money, buying assets, investing the funds, constructing factory and all. Like all that will come here. This is standard. This is given in the table. This is not given. If you want, you can change it, but this is given in the table. It's available. In those days, we used to have something called other objects. Now that other objects, no. What we used to do, in the other objects, we'll put 100 objects. Whenever we want, we'll adopt it. Now, no. Only main objects, incidental objects. Okay. This is the subscription. You can see that. The 6th clause. Then you have the liability clause. The liability of the members is limited to the amount unpaid, if any, on the shares. So limited by shares, table B. Then the authorized share capital, 1 lakh, small. Service company, no? That's all. So we the persons whose names and addresses are here to subscribe. So this is the subscription clause, or desirous of being formed into a company. And we respectively agree to take the number of shares. Okay. What happened was there was an earlier memorandum. The entire memorandum was taken away and new memorandum was put when the name was changed. And also we have to clearly mention, whenever a company changes the name, there should be a clear indication in the memorandum that the company has changed its name from so-and-so to so-and-so.
so that any third party will know, hey, this company was Blue Dot, now it is Prometheus, like that. So these are the two people who were the original signatories. So like that. So witness is also there. All have originally signed. This is only next step. So this is the articles. Okay. Again, table F straight away. Full table F straight away adopted. You can see one thing I'll show you, and then I will stop because time is up. See that the private company will have to, by its articles, have to restrict. See, private company. The company is a private company within the meaning of Section 268 of the Companies Act, restricts the right to transfer shares, limits the number of its members to 200, okay, etc., and prohibits any invitation from the public to subscribe for any securities. So I just thought I will show this to you. Of course, you can go to the ministry website and you can, go through that and you can get that. Now, see, I was honestly thinking, my dear friends, that we can complete this topic today, but we are not going to do it. So what I will do in my next class, I'll be covering, alteration, completing. Next class, we will complete the topics. Incorporation. Okay, this is the plan. So now we have, so we have people from Coimbatore who are saying they are from Coimbatore. Good, but I'm a partly resident of, but not ordinarily a resident of Coimbatore. I'm an ordinary resident of Chennai. Anyway, now, yes, Ms. Sharuha, this is not the forum for that. I cannot do that. Maybe I don't know how it will happen, but not in this forum. Already time is there. And thank you for my English. Of course, what to do? Developed over for 50 years. Because 50 years of development, it happened like this. Not overnight, one shot. Thank you, Ms. Biola, for the thing. Thank you. Inshallah, we'll pray that you all should clear. Thank you. Durga Rani, what is she saying? Durga Rani. Thank you, madam. So nice of you. Thank you, Ms. Durga Rani, for your kind comment. If that is what you wanted me to take note, I'm much obliged to you. All of you who there, just go to mca.org. You have to register. Go to mca.gov.in, MCA, then register. You have to give your email ID and you'll get a password and all. Then you go there, you can search. Then put the company's name, you will search. That's all completely menu-driven thing. But you have to get yourself registered first. So today, we will stop here with this and we will hope to complete this topic in the next class only. That is how it's going to be. Thank you very much. Wishing you all a great evening and looking forward to completing this topic on 19th, inshallah. Thank you. Bye.